Well, welcome everyone. Thank you so much for being here. This is our fourth session in our Women Getting Wise About Wealth series entitled Estate Planning and Philanthropy. See if you guys can say it. My name is Holly Knight and I'm the Director of Retirement Outcomes for Sapers Wallack. And today's session is going to be facilitated by my colleague, Aviva Sapers, in the box over here for me. She's our CEO. And special guest, Melissa Sidney from Tarlow, Breed, Hart, and Rogers. I'm really excited to learn some more about this topic from these two experts, and I hope it helps demystify some of the questions you may have in regards to estate planning. So a couple of household tips before we get started. We are recording this session, so please mute your microphone if I haven't done so already. It looks like everybody has. Along those lines, if you have any questions at all during the presentation, please put them in the chat section. Both of these ladies love questions, so please feel free to ask them. I'm going to facilitate those questions towards the end. And then the last thing I wanted to mention, this is our fourth presentation, our fourth session in this series. If you missed any of the previous ones, you will be able to locate the recordings of them on our website. And I'll put that link into the web or into the chat section. So in that same spot, you can also register for our last two sessions that are coming up. So with that, I think we're good. So I'm going to turn it over to Melissa to get us started.
Sorry, in the interest of not having any background noises, I had my mute turned on. I guess that's a hazard of current Zoom life. But thanks everyone for joining today. I'm thrilled to be here with Aviva. And I'm a trust and estates attorney. I'm a chair of the trust and estates department at my firm. So I spend a lot of time exploring these questions and other related issues that come up for my clients. And the first question that you guys are probably thinking about is, what happens if someone dies without a will or an estate plan? And Massachusetts law actually steps in and says where your assets are going to go. And what's provided for under Massachusetts law really depends on what someone's family situation is. If they're married, if they are not married, and whether they have children with their spouse. So if someone is married and their only children are also children of their spouse, then 100% goes to the surviving spouse. Otherwise, it depends on where the other children are, or who they belong to, I should say. So it gets divided between a spouse and non-marital children, if there are non-marital children. And then if there is no spouse or no children, then it goes all to the parents of the person who passed away. But most people don't want to fall into the Massachusetts default statute. So I would say about 50% of Americans make their own estate plan, but that does mean that one half does not.
So you might ask, what documents have to be used in order to have a comprehensive estate plan if you choose to not be the half that are that have no planning done and they're going to fall to the demise of whatever the state puts in their way. The basic documents that make up a comprehensive estate plan are wills, and those designate where most of your assets go upon your death, and then trusts, which are either formed at your death as a structure for assets to go into and to be managed for the beneficiaries, or used while alive to avoid the probate process when you die. These trusts are created to move assets out of your estate while alive to avoid future estate tax too. Trusts can be created and funded to help take care of children who may never fully be able to take care of themselves. And they're often used to keep assets moving down generationally within a family and protecting those assets from marriages or divorces of your children, sort of the in-laws versus the outlaws. Then there's a document called a durable power of attorney. It's included to assign somebody the power to make financial decisions on your behalf if you're not cognitively able to do so. And a healthcare proxy, which appoints somebody to make health decisions on your behalf if you're unable to do so. And that could include a form, a do not resuscitate type of election, to whether you should be on continued life support or more.
Great. So I'm going to talk about a will in a little more depth. A will is a document that takes effect at death. It can be changed multiple times before someone actually passes away. And the will states who is actually going to get someone's assets when they pass away. It also names the personal representative, which is the current term for executor under Massachusetts law. And that's the person who administers the estate. So they do things like filing the final estate tax return, or filing an estate tax return, the final income tax return. And then if there is an income tax return for the estate, the person would handle that as well. The personal representative also takes care of paying any debts. So if someone has outstanding credit card bills or medical expenses, the personal representative takes care of that as well. One of the most important aspects of a will is that it also allows someone to name a guardian if they have any minor children. And the Massachusetts probate code was updated about 10 years ago. And since the update 10 years ago, not only can people name guardians for minor children, if they have a child who is disabled and under guardianship, or a spouse who's disabled and under guardianship, a successor can also be nominated through the will. So it's a pretty important document.
I forgot to ask, how many of you, by show of hands, have wills, have done your own preliminary estate planning? Can you put up a hand if you've done your own? Okay, good. Just wanted to take a quick check there, because didn't want to be getting into too many boring details if you have these and know what they are.
And I have to say, as an estate planning attorney, I'm thrilled to see by the number of hands that went up.
Nice.
It's always easier to plan during lifetime than kind of throw up the chips and do it after the fact. So in considering an estate plan or a will, people may ask, who's a good person to name as personal representative? And it could be one or more people. Some people name family members or friends. And depending on the situation, it may be appropriate to name a professional. Usually a professional is only named if there's a lot of complexity or people don't have anyone else they want to name, or if they think that there's going to be a little litigation situation and they need kind of an independent third party who can administer the assets to keep the peace among everyone.
Melissa, I know we're not in Q&A yet, but would you recommend someone younger than you?
It depends on your age. So
Fair
I
enough.
would say someone who's in their 40s, 50s, 60s, they can name contemporaries. Once you get to 70s, 80s, 90s, probably not a good idea to name a contemporary. And I know this may come up later, but this is so important. I feel like I need to repeat it anyway. The people that you're naming should be reviewed every few years just to make sure that they're the right people and that they're also able to fulfill whatever duty you're naming them to. So a lot of times I see with my clients, they may name their parents as guardian first time around, which may make sense when their parents are in their 60s. When their parents get into their 70s, 80s, or even 90s, they're probably not an appropriate choice anymore for guardian, or perhaps even personal representative or executor. And as I said before, the executor handles all of the tax returns for the person who passed away. So it's final income tax returns, a 1040, any estate income tax returns, and then also if the estate is taxable, which we'll talk about a little later in the presentation, the personal representative would also take care of preparing or submitting the estate tax returns.
So we also, one of the other things that you generally do in a will is you name a guardian for your kids if you have kids who are underage, or if I guess if you're on the older side too, and you may have a very senior parent who is no longer able to care for themselves. So we talk in terms of who you might want to name, And usually if you have young kids, it's who's the person that you'd best want to raise your kids and raise them in the fashion like you would raise them, or that you prefer they could raise better than you'd raise them. And that's who you'd name as a guardian. A conservator is a person who handles the financial matters for the kids. Oftentimes they're one and the same. And this role is usually done when there is not a trust with a trustee who handles the financial stuff. I think we often recommend people have their financial assets at their death be moved into a trust with a trustee who handles the financial matters. But many times there are guardians who are very good financially, and it's a great thing to combine the two. You can name one or more people as a guardian conservator, so it could be your brother and sister-in-law or something like that. But you also want to make sure that you have can come up with a successor situation in case your siblings, your brother and sister-in-law get divorced, so that there's something noted there in the plan documents, and sort of take care of it that way. But all of these things would be specified in good set of documents that are well drafted by an attorney. And same thing as you can name a guardian, but if your spouse is still alive when you pass away, the use or the raising of your kids will still be by your spouse, unless for some reason you have a spouse who's unable to do so. So that would be the typical scenario where not much of this comes into play until both of you pass. The other thing is, how often should you review this? It's kind of like anything. You want to do it periodically. As Melissa mentioned, every few years, or when certain life events happen, are the times to review your estate plan and to potentially make changes. Some of the things that might cause reason to review would be moving to a different state. You were Massachusetts residents, now you become Florida residents, or you move to New Hampshire, or whatever it might be, or a change in marital status. So you've gotten married, you've gotten divorced, your children are now of age, they've grown up. That might be a reason to change around some of the provisions. You might want to or need to name a different personal representative to be a guardian. The person you thought was in your life and dear to you and the kids flips out and is no longer somebody that you feel confident in and being able to raise your kids. That'd be a great reason to make changes. Change in the distribution of assets. You thought your kids were able to control their own financial matters, and you find out one of them's got a gambling problem or is an alcoholic, or there's something that comes up there. So that would be something that you'd want to think about. And then maybe Congress changes the tax laws. And if you are sort of tax sensitive in your planning, you want to make sure that you've actually re-looked at what you have to see if it still takes the best advantage of some of these tax situations. You may also have a big change in the value of your estate. Today you weren't, last year you weren't worth much. This year your company went public and you've got all kinds of millions of dollars of stock options and things that have now added tremendously to the value of your estate. Most estate plans are set up to handle additional children, but there are some who did these years ago when they first got married and maybe had their first kid, and they mentioned Susie, Tommy, whoever the kid was in the will. Thankfully, most lawyers don't draft this way anymore, and some never did. But if it just refers to one kid and you now have two other children since that point in time, and you don't have it including language like all children equally, or just not naming specific children, you could avoid a situation or be in a situation just because it wasn't drafted properly and at the time, because you haven't reviewed this in many years. And I have a client who actually did this. When I met with him to review his insurance stuff, I said, when was the last time you reviewed your estate plan? He said, about 10 years ago. I only had one kid at the time. Now I've got 4. So it was important to go back and look at the provisions and see who was going to get what. The reason that your plan should be revisited is because of your change in circumstance could cause new needs for planning. You might now want to do something different with regards to children. If you have a disabled child or somebody who needs certain care, those are the types of things you want to revisit along the way. And any change in your life could change your tax status. And if you want to do prudent planning around tax stuff, this would be a great time to do that. There are some questions in the chat. I can't see the chat on my computer. I don't, Holly, do you want to read them now? Or you want to wait till later?
Actually, we had someone who asked if it's specific to Massachusetts, if we're just because this person isn't in Mass. So are you? So
If what's specific to Mass, all of this, the stuff that we've covered so far is for any state.
okay.
Yeah, I'll just jump in and add the legal perspective. So what I started off with in terms of what happens with your assets if you don't have a will, that may be different depending on what state you live in. But whatever state that is going to have its own regime. But that doesn't change the fact that most people want to elect out of the default and should get an estate plan. And these documents would be, the same in any state that someone lived in. And really the most important things is just to review it and make sure it's up to date. And that is definitely true regardless of what state you're in. I'm licensed in Florida as well as here in Massachusetts. And I had a client who in Florida, she had an estate plan that provided for her mother and brother. And before she had passed away, she had adopted 3 children who were all minors, and she hadn't updated her estate plan. She unfortunately died very suddenly from she had an asthma attack and died immediately from it. And we had to do a lot of, I would say, jumping through hoops to make sure that the estate plan went to the kids. And because of the defaults under Florida law, we were able to get there, but would have been a lot easier and a lot less expensive for the estate if this person had had an up-to-date estate plan that reflected her current life situation.
Good.
And people may ask, what is a trust? They hear about them and they think, oh, I don't need one. It's only for really, really wealthy people. And I will say people who are ultra wealthy do use trusts, but here in Massachusetts, and this may be true in other states as well, people tend to use trusts in conjunction with a will for multiple reasons. One reason is to avoid probate. Anything that's held in a trust at the time that someone passes away does not go through probate. And I will say, dealing with any court right now, regardless of where you live, is a huge, huge hassle because of COVID. And a lot of courts, excuse me, are handling things remotely. So I always tell my clients that if you can avoid having to do probate, it's a great thing. The only people who really benefit from it is the lawyers. They get the extra fees from doing probate. So I always tell my clients that I highly recommend they try and make sure they have no probate assets. And just to take a step back, a probate asset is an asset that's only in the name of the person who passes away, and there's no designated beneficiary. So a bank account that's just in my name, that would be a probate asset. The house that my husband and I own together, that is non-probate, because if I pass away first, it goes right to him. Life insurance and retirement assets, because they have designated beneficiaries, those are also non-probate. And it also, just from a time perspective, is so much easier to avoid probate. And a lot of people do that by using a trust. The other benefit of a trust, and there are multiple types of trusts, is that if someone becomes incapacitated, whatever assets are in the trust at that time can be managed by the trustee, which generally is easier than using a durable power of attorney. And there are multiple types of trusts. There's a revocable trust, which is a type of trust that I was just talking about that works in conjunction with the will. And then there's also irrevocable trusts that are more difficult to change. And those are generally used for a specific purpose. For example, they're used to hold life insurance, so that way the life insurance proceeds are outside of someone's taxable estate. With all of the exciting discussion around taxes right now that are happening in Washington, I'm pretty busy helping my clients make gifts into irrevocable trust for their children. And the benefit of these types of trusts is that it takes the asset and places it outside of the taxable estate of the donor who makes a gift, and makes it available for the recipient, known as the beneficiary. And the beneficiary has access to it, but it's because of the trust structure, it's protected from the beneficiary's creditors. So it's a very, very common structure that is used to protect assets and also for some tax savings. And then
the only thing I would add there is that irrevocable trusts try and get things out of your estate today, so that you may still want some control over some of them, but you really don't. You don't have that control once you choose to make it irrevocable. And on the other hand, it is a great way to take assets and move them outside of your estate for your kids, for the benefit of your spouse or whomever else.
Yeah, and I would say the control issue is something that clients always struggle with. They want to give away the whatever 10 million, whatever amount it is, but they want to make sure that they control it. And the IRS likes challenging those types of situations where someone has put something in a trust, but hasn't really given up all of the control.
Right.
And then before we move on to the next subject, I know we'll get to this, but does anyone have any questions about trusts? Holly, are there any questions?
Yep, I have one, but I think you may have answered it. Can an irrevocable trust be changed? And should life insurance be owned by a trust?
So those are great questions. A lot of attorneys put provisions into irrevocable trust to make them more flexible, and that they are easier to update if there's a change in tax laws or if there's a change in circumstance. But it depends on what the provisions of the trust are, and then also what state law is governing changes. So here in Massachusetts and in other states, we have something called a non-judicial settlement agreement that allows trustees and beneficiaries to change the provisions of a trust without going to court. Previously, you had to go to court to do some changes. So that's one way to get trust changes. Another thing that's allowed under Massachusetts and some other states as well is something called decanting, where you take a trust and, as it sounds like, decant it or pour it into a new trust with different provisions. And the ability to do that really depends on the provisions of the trust and the laws of the state wherever the trust is being administered. So I'm giving you the typical lawyer answer.
It depends.
It depends.
And you can't just decant any trust either. There's got to be a real purpose, right?
Correct.
Yeah.
Correct. And it has to, you need to make sure that either you fall into the requirements under state law, and every state has different requirements for that, or if it's authorized under the terms of the trust.
Good.
And just the other question about life insurance, should life insurance be held in a trust? And traditionally, it has always been held in a trust. There's some exciting conversations that are going on in Washington right now that I wouldn't say are going to stop using trusts for life insurance, but may potentially make it more complicated. But I have a very cloudy crystal ball, so I have no idea what the final legislation is going to look like on that.
But it is a good asset to get into a trust, because when it's never going to pay out during your life if you're buying it just for the death benefit. And if it's a second to die, it's going to be out of yours and your spouse's estate. So it's a great asset to move out of your estate now, because you're really not planning on benefiting from it. But to Melissa's point, there are some new proposed rules that may make it a little trickier to make those work properly. But if you have one, you're in good shape.
Yeah, and one thing I just want to mention before we move on to the next subject is trusts are generally private documents. And that's why people like them as well, is that they're never submitted with a court unless there is some type of litigation. So they remain private. And so they're never really filed with any jurisdiction. Or
Right.
with
And
any
that's
government
really,
authority.
the whole probate process is really public knowledge, right? That's out there for anyone to look at, which is why it's important to create trust. And I'll add one thing about trust before we move on to these other things. Many years ago, we found that we had clients who spent a lot of money and time with lawyers drafting documents and all that and creating trusts, but never put any of their assets in them. They didn't change the titling to move the assets into a trust to benefit from all of that great planning they did. And I'd equate that to saying, geez, if I ever got robbed at home one night while we're sleeping, I don't want my jewelry or my fine watches all stolen. So you buy this really expensive safe that's bomb-proof, fireproof, pick-proof, whatever, and it's underneath your counter. But every night you come in and you put your watch on the bureau and you put your earrings on the bureau and your gold necklace on the bureau. You never put it in the safe. And the burglar comes and can just do a clean sweep. It's no different with trusts and putting assets in those trusts. You do need to actually retitle things and move them over if you're going to take the time to create trusts.
And I will say it's so important to provide your attorney with a list of all of your accounts when doing that. I have a client who unfortunately recently passed away, and there was one account that he never told me about. And so we have to do a probate just for that one account, even though everything else was in the trust. So,
yeah,
at least the other assets are sheltered from probate, but if we had had an exhaustive list, we could have dealt with that asset as well.
exactly.
So moving on away from trusts, it's really important that people have durable powers of attorney, healthcare proxies, and HIPAA waivers. And the power of attorney allows you to name someone, an agent, to handle your finances. And one thing that's really important to note about a power of attorney is that it's effective as soon as it's signed. It's planned to only be used for incapacity, but as soon as someone signs a power of attorney, whoever's named as agent can take it and use it immediately. So in my mind, this is probably the most powerful estate planning document. And it's so important, as with any of these other positions, to make sure that you're naming the right person. There is something called a springing power of appointment that only becomes effective when the principal or the person who created the power of attorney is incapacitated. But those are used very infrequently, and some states like Florida don't even recognize them. So all of the durable powers attorney that I draft and the ones that I come across are not springing, but are effective immediately. Similar to a durable power of attorney, there's a healthcare proxy, and that allows you to name someone to make medical decisions for you. The healthcare proxy is only effective when someone can no longer make decisions for themselves. So, for example, I have a healthcare proxy. I name my husband. He is not authorized to make a medical decision for me until I'm incapacitated and can't make them for myself. One document that works in conjunction with the healthcare proxy is a HIPAA waiver. And the HIPAA waiver is really important because it allows whoever's named in the HIPAA waiver to access protected medical information. So, for example, my husband may not be able to make medical care decisions for me, but if I'm in some type of surgery or whatever, he can use the HIPAA waiver to get access to my protected medical information. And it's a great way for people who have children who are older, who may want to give them the ability to speak to a doctor, but not necessarily want to name them as the healthcare agent. It's a great way to provide the adult child with access to information. And I should mention that for a healthcare proxy, I recommend that people only name one agent to serve at a time. Because if there's a split-second medical decision that needs to be made, that's not the time to start fighting over what mom would want or whatever you would want. So I recommend that only one person be named at any given time.
And I would add to that, if at all possible, that they be local. We went through this with my mom and realized, I'm not sure we found out, we knew, but we forgot that my brother was named the healthcare proxy for her, and she had to go into surgery, and he was skiing in Utah. They had moved out there for the winter, and trying to get him on the phone to give permission for them to do what they needed to do was a pain. And if thankfully he responded fairly quickly, but if we hadn't heard back at all, it would have been a problem.
Yeah.
The other thing I'd say for those of us that have teenage kids, the older teenage kids, you sort of forget, but your kid may still be living under your house, may have gone to college, and they become, at the age of 18, they become their own legal guardian for themselves when it comes to their medical decisions. And many of them are not necessarily of fully developed mind to make those decisions on their own. And so getting them to sign a HIPAA waiver, giving you the opportunity to have access to their medical stuff is very important if you want to be a part of those decisions.
Yeah, that's a great point. I know when my clients, their kids go off to college, they lose the ability to speak to whoever is treating them once they turn 18. So having that HIPAA waiver can just help facilitate treatment for a child who is legally an adult, but still young.
Right.
And moving on to taxes, we're in a really exciting time right now to talk about taxes. If anyone's been following the news in DC, there's proposals out there to change the current tax regime. And as I said, I have a very cloudy crystal ball, so I don't know what's gonna happen. But currently under federal law, the estate tax exemption amount is 11.7 million per individual. So for someone who's married, it's almost $23.5 million that a couple can transfer free of any transfer taxes. Given these numbers, it actually impacts very few estates annually. It's, I think it's like 5,000 estates that even file an estate tax return, given these numbers, and only 50% of those estates even pay any estate tax. So it comes out to about 2,000 estates per year that actually pay an estate tax.
At the federal level.
At the federal level. Under current law in 2026, the exemption amount is going to be split in half and go down to about 6 million or 12 million per couple. And that there are proposals to reduce that as of January 1, 2022. And again, we'll see what happens. I have a feeling that it may go by the wayside and just be a bargaining chip, but I've been wrong before, so it's very likely I could be wrong again. And here in Massachusetts, we also have a state estate tax. That's not true in every state. And our estate tax is 1 million per individual or 2 million for a couple.
Our exemptions, the amount you can leave without paying estate taxes.
Correct.
Right. And the tax rates for Mass residents start at what level, Melissa?
So it's a graduated tax. So the maximum tax is 16%, and you hit that when you have about 10 million of assets. And for people who are just over the $1 million exemption amount, it's about an 8% tax. And federally, the tax is much more significant. It's a 40% tax.
Much bigger.
Yeah. So for clients who are over the federal exemption amount, obviously it means they have a lot more in assets, but the tax is going to be is significant. You know, on every 1 million over the exemption amount, 400 is an estate tax.
Yeah.
And as I've mentioned a couple of times during this discussion, there are proposals to change the current estate tax regime. And one of the things that's in the current Ways and Means bill that's in Congress right now is to change the date of the sunset. So when the exemption amount is reduced. And as I said before, it's under current law that's scheduled to change in 2026, January 1, 2026. And under the House Ways and Means bill, that would happen January 2022. There's also been proposals to increase the maximum estate tax rate. And that's, you know, the proposals out there that have been introduced into Congress have been all over the map. I don't know what's going to happen with the estate tax rate, but we'll see. And then one of the things that I think every attorney like me is dealing with right now is a lot of the sophisticated estate planning techniques that we use to help our clients. Congress is talking about getting rid of them. So one item that's very high on the agenda, which has everyone like me kind of shaking in our boots, is the way that irrevocable trusts are taxed from an income tax perspective. And then also, depending on the income tax treatment, what that means from an estate tax perspective. So I don't want to go too much into the weeds, but I'm happy if people have questions to answer them either during the Q&A or after. But it's causing a lot of people to be worried about doing their strategic tax planning and trying to get it done before any changes become permanent.
Right. The current tax rates come 2026 will move to about half of what they are now. But under the Biden proposal, I think it's going to be a half below that. So I think that the exemption would go from 6 million to 3.5 million or so, I think is what one of the.
Yeah. So
provisions.
that's what Biden proposed, but that's not what's that's not what's before Congress right now.
Got it. Okay.
And the House has its version of the bill. It's in the House Ways and Means Committee. The Senate is going to come up with its own version. And then the houses are going to have to kind of hash it out to come up with something that they want to put before the president's desk. So whatever is current today, I would say fasten your seatbelt because it's going to change a bunch of times before it actually gets to Biden's desk.
Fair enough. That's why you've got a murky crystal ball.
Exactly.
Things are challenging. So let's change gears for a second because it's part of estate planning. And a lot of times people don't think about it, but let's talk a little bit about philanthropy. I want to start just with a show of hands again. How many people actually give annually to some charities or nonprofits that they support? Show of hands. Fair amount of you. Good. So first question is, do you write a check? How do you make those gifts each year? Credit card, check? Show of hands for how many people write checks or use credit cards? Okay. So how many of you have used or have heard of something called the Donor Advised Fund? Show of hands. Okay. Well, so to me, the smartest way to make a gift to charity is not by writing a check or using a credit card. And there are definitely exceptions to my theory here. But you're better off donating if you happen to have outside stock. So you might, you have stock in a portfolio that's not part of your retirement plan, but you're just another stock portfolio. Those are better assets to give if they've appreciated in value, or real estate and art. If you're a big donor, those are other types of assets that do appreciate in value. The reason for doing that instead of giving cash is because you don't pay taxes on the gain in those assets when you give them away. If you sold them, you have to pay capital gains on a sale of a stock or real estate or art. But if you donate them to charity, you don't. So for example, if you owned 100 shares of Google, which you bought at $10 a share, but it's grown to $100 a share, your shares would now be worth about 10,000 bucks. If you had planned to give away 10,000 this year to charity, you're better off donating the stock to the charity because you won't have to pay the capital gains on 9,000 of Google stock if it's gifted to charity. And you say, but wait, I want to own Google stock. It's doing amazingly well. So instead, just before you make your donation, you go out and buy $10,000 worth of Google stock. So now you actually have $20,000 worth of Google stock, but you give away the 10,000 that you had before. And therefore you still end up with 10,000 in your portfolio, and you can then have that multiply over the years to come. But many people don't realize that they can donate stock, and that many charities are more than happy to take a donation of stock. So from an annual giving perspective, that's sort of my one takeaway that I might share with you for annual giving tricks and tools of the trade. But people also don't realize that giving doesn't have to be just an annual thing. It can be included in your estate plan. How many of you have heard of the word bequests? So if you've done philanthropic stuff, bequest means I leave it to this organization at my death. And how do I do that? I do it through my wills and through working with my attorney to make sure that those are specified. You can designate a small piece or all of your estate to go to charity when you die. It can go directly to one charity or different charities in a specified amount or in percentages of your estate, or it can go into a fund, a donor advised fund or a trust to be distributed by your kids over many years to come to different charities. So that can include some participation from your children if you want them to continue your legacy of being philanthropic. And those are called bequests. Any of these can affect your documents depending on how they were drafted. And it suggests as part of the reason to now review a will is to, if you've had a change in financial circumstances where you want to be more philanthropic than you used to be, or now that your kids are older and seem to be doing pretty well on their own, you may not feel you have to leave them quite as much. It's a great opportunity to say, okay, now I can leave $1 million, $500,000, $100,000, or even smaller amounts when I die to some organizations that have been meaningful to me and are doing great things for the community. So we'll talk a little bit about philanthropy. It is something that you can do as part of dying. It's something you can do while you're alive. But as you think through your estate plan, when you give assets away at death, they're not included in your estate for estate tax purposes. A lot of people here, if you have an IRA and you're getting closer to the 70s, they'll let you donate right from your IRA, and so you don't have to pay the income tax on that. But at your death, if you have a large enough estate where you might be in a pretty hefty estate tax bracket, it's something to give some thought to. And then just as a sidebar, when I said some people, I think it's smarter to give away stock than writing checks. This particular year, and there's some of the new tax laws, they do allow, there's a specific limitations which have been eased on how much you can give and actually write off. This year, if you donate cash, you could deduct up to 100% of your adjusted gross income or your earnings for that full donation. It used to be, I think, as high as 60%, but now it's 100. You can deduct 50% if you're giving something other than cash, usually stocks or appreciated assets. So I throw that out there just because we do have a short window, but I don't know anybody, or I've not met anyone who's been willing to give 100% of their earnings away to charity. I wish I met more people making that, I guess, that much more money that felt no problem. They're happy to do that. But that's just a specific exemption this go round. And donor advised funds, just want to spend a minute on those for folks. Donor advised funds are charitable funds which you can donate appreciated assets to, or cash, though it's more cost effective, as I just said, to donate appreciated assets like stock and get a tax deduction in that year. When you make a gift to a donor advised fund, you are, instead of writing it to XYZ charity, you're creating one of these funds or using existing funds through major institutions. I'll get to that in a second. And you give them the stock and or give them a piece of real estate or whatever it might be. You different types of donor advised funds allow for different assets to be donated to them. But in order to get a good tax deduction, you may decide, you've heard maybe about doubling up and trying to give more money away in 1 year because the tax rules changed a couple of years ago, where you don't get enough of a deduction until you've given a certain amount away. So some people have kind of lumped them together, but they don't want to give all that to a nonprofit in that specific year. So you have the opportunity to take a larger asset, which you might want to do to offset earned income that year, or a sale of an asset that has a lot of gains on it. You may want to get a charitable deduction to offset some of that, or you have to take big distributions from an IRA because you've saved enough money in your retirement plans. Giving a donation of a significant amount, maybe more than you want to actually give to charity that year. So using a donor advised fund, you can gift, let's say, a $20,000 appreciated asset, but only give away, if you normally only give away 5,000 a year, that's all you have to do is give away that 5,000, make a designation from that donor advised fund to whatever charities you want for $5,000. The rest sits in the fund and is invested and continues to grow, and you can then make gifts throughout the rest of your lifetime, and maybe beyond your lifetime, your kids can make gifts with what's still in that fund. It's a great way to make gifts to smaller nonprofits as well. So you might have a church or a temple that doesn't have an account set up to receive stock. And here I was just telling you stock's the best thing to give. And you want to give it to an organization that's too small and doesn't really have the financial sophistication to have trading accounts and doing all that. The donor advised fund can accept the actual donation, and then you tell them, hey, I'd like you to send a certain amount of money over to this church or this temple on my behalf. And so they can take care of that for you. The types of organizations that have donor advised funds, you might be familiar with. Fidelity has something, Schwab has something. If you're Jewish, the Combined Jewish Philanthropies has one of the larger donor advised funds around, as well as the Boston Foundation. And entities like CJP or the Boston Foundation have a greater capacity to receive more unusual types of appreciated assets, like shares of a company, closely held company, real estate, and artwork. And just to give you an interesting sort of application of this that we used when I ended up buying into our family business. My dad, who if he would either have had to give me or sell me his shares of stock. If he gave them to me, he would have to pay probably part or use up some of his lifetime exemption or pay a gift tax. If he sold them to me, he'd have to pay capital gains tax on the appreciated value. Instead, he donated them to his donor advised fund, and I purchased them from his donor advised fund. And as a result, he got a charitable deduction for it, and I got to buy them at full value. Lucky me. But at least he was able to have a good tax advantage, and I was able to get the assets at their full value. So those are some initial thoughts on philanthropy. There's tons of stuff we could go into on that score, but wanted to just give you a couple ideas of things that we have used in the past. Questions?
So I see a couple of questions in the chat about gifting and what to do right now. One thing, someone asked whether gifting limitations apply to spouses. If your spouse is a US citizen, then you can give as much as you want to your spouse. And if you are a US citizen, you can receive as much from your spouse. The rules are a little different if the recipient spouse is a non-US citizen. And someone also asked if they're gifting to if they want to make gifts to their children or grandchildren, should they consider doing it now? And I would say an emphatic yes. You know, I can't, as I said, I can't predict what's going to happen, but I think now is probably a good time to do gifting if you're contemplating doing it. The other benefit about gifting is that even if the exemption amount goes down or stays the same, the nice thing about gifting is that it's out of your taxable estate. The IRS does not assess a tax for any amount that's gotten out of your estate while the exemption amount is high. So if, for example, currently the exemption amount is 11.7 million. If someone makes a gift of 11.7 million and then the exemption amount goes down, well, that 11.7 is free and clear and is not going to be subject to any transfer taxes in the future. The other item that I think is really important is that all future appreciation is now outside of the taxable estate as well. So it's not only the underlying asset, but if there's another 20 or 30 years before the donor passes away, then you have 20 or 30 years for that asset to grow in value. So that also is a pretty powerful planning tool.
I'm just scanning back through the chat now that I took it off presentation mode here. A question was asked, when a trust is set up, where is it filed, or is it just with the lawyer?
I think we addressed that question, that it's a private document. And
so a trust itself, depending on what kind of entity, if it's a live trust versus one that gets formed at your death, it usually has its own tax ID number, and you have to file a tax return for it every single year. But it doesn't live in, it's a physical document. I mean, it's really an entity that has a tax ID number. The actual document can be in your own possession in a safe deposit box. It could be at your lawyer's office, etc. And then there was a question about.
I just jump in and say something, Aviva, about
Sure,
what
of
you
course.
said about the safe deposit box.
Yeah.
A lot of people put their estate planning documents in their safe deposit box. And I do not recommend that, because if they are ever needed and you're not available to get it, it creates a huge challenge for whoever it is that's named in your documents to locate the documents, because unless that person's name is on the safe deposit box or they have a key, it is so challenging to get in there and get that access to the documents.
Your response just raised another interesting thing that crossed my mind. We don't talk about our digital estate, but all of us have a digital estate and access to all kinds of things through the computer and the internet. And one of the things that is helpful for folks is, if you do keep things password protected, you should let your spouse know at least how to access it. Maybe that's in a document they see when you're gone, but you want to, if you for some reason don't want to share it while you're around, but letting them know how to get access to those things is important. To your point, Melissa, I don't think there's no great reason to put it in a, people don't even go to banks anymore, but in some sort of lockbox, because nothing happens with your documents unless somebody wants to get a sneak peek of what they're going to inherit someday. So from that standpoint, I think that making sure your digital stuff is accessible to your spouse is great. In addition, when we're talking healthcare proxies, that's another one where people forget. If you can put something on your phone, whether it's a file or a folder or access on your own cell phone, you get in an accident, they ship you to the hospital and they ask you if you have a healthcare proxy. And like, of course I do. It's in my file at home with all my other legal documents. Well, that's great, but what does it say? And they need a proof of it. So to have a digital version on your phone or access digitally saves everybody a lot of time, because what ends up happening is you don't have it with you. They ask you to do a new one, and you might have thought long and hard that it should be not your spouse, but your sister or your brother, because they think more like you in terms of whether to pull the plug or those types of things. And instead, you're not thinking because you were just in an accident, and they shove a piece of paper underneath your nose because you don't have it with you, and you just sign off it should be your spouse now or something, or vice versa. And now the person who's got that authority isn't the person who was the one you wanted to have that kind of authority. So making those things available and not in a lockbox is a great piece of advice that I'd share.
Yeah, and I also recommend that for people's healthcare, for their healthcare documents, like the healthcare proxy and also the HIPAA waiver, that you provide a copy of those documents to your GP. And that way your GP will have them, and hopefully they'll become part of your electronic medical file. And I just want to say something about, I know we didn't discuss it, a living will. that is a document that gives your healthcare agent guidance as to what you would want happen if you are if you're in an end of life situation. Here in Massachusetts, they're not legally binding. They're just evidence of what you would want. But in other states, they are legally binding. So for example, in Florida, the living will is legally binding and is legally enforceable if a doctor or healthcare agent doesn't want to enforce it.
Other questions? Well, good set of questions today. Thank you all. I will share my screen for one more moment here, only because there's basic contact information here. But having said that, we're going to be sending around to you all the information that you might need to contact us. This is recorded, so it'll be available on our website. We'll be sending links, and for people that either had to leave early, or if you know people who might be interested, feel free to share a link so that they can get access as well. Melissa is an outstanding estate planning attorney, which is why we asked her to do this with us. If you need a refresher in your documents and you're not wedded to someone who might have done them a while ago, I suggest you give her a try.